Good morning, everybody. My name is Hal Johnson. I'm a partner here at Williams Mullen and co-chair of the education practice. And on behalf of our program partners, Ernst & Young, Marsh, Mercer, and our firm here at Williams Mullen, I want to thank you for joining us this morning for a webinar on college retirement plan compliance, especially in an era of increased litigation. Providing the presentation today will be my colleague, Brydon DeWitt. Brydon is a partner in the Employee Benefits and Executive Compensation practice here at Williams Mullen, and he's worked with a number of educational institutions over the years on employee benefits issues. We're also joined by Marc, who's also a partner and chair of our Employee Benefits and Executive Compensation practice, and an associate from that practice, Yascko-Rosado. The voice you will hear primarily today, though, will be that of Brydon DeWitt. Before we get started, I want to hit on a couple of programming or housekeeping topics. This webinar is the first in a series of events that we have on tap for our clients and friends in the education industry. We've done some webinars in the past, and we, along with our friends at Ernst & Young, Marsh, and Mercer, will be presenting on select topics throughout the course of the year. The next event on the calendar, which we hope is on your calendar as well, will be the 4th annual half-day seminar, education seminar, held here at Williams Mullen in Richmond. That is scheduled for October 4th, which I believe is a Wednesday, if I'm not mistaken. And of course, the best news about that is that the program is free and includes lunch. We'll be sending out invitations for that seminar probably in the coming weeks. We're busy putting together a program that we think will include some topics that are of interest to everybody and sort of at the forefront of everyone's mind in the education arena. Following the discussion today, we'll be sending a link to this presentation so that you'll be able to revisit it as you wish. While Brydon is presenting, we would encourage you to ask your questions using the chat feature, which you should see in the upper left-hand corner of your screen, and we will collect those questions and answer them at the end of our presentation. In the event we run out of time to answer all of the questions, don't fret. We will, consistent with our past practice, gather those questions, and in the coming days, Brydon and his team will put together an email that responds to those questions, and we'll send that along to each of you. Please place any cell phones away from your landline. That sometimes results in interference. And also I would ask you to put your phones on mute if you've not already, so that we can eliminate any background noise or distractions for other listeners. With that said, I'm going to turn it over to Brydon for today's program.
All right, thank you, Hal. And thank you, everyone, for joining us for this webinar. The somewhat cryptic title, College Retirement Plan Compliance in an Era of Increased Litigation, the title could have really been the University 403B Litigation. When we were considering topics for this webinar, it was just inescapable that with really starting last August, over a dozen universities have been sued alleging breaches of Erisa fiduciary duty with respect to their 403B plans. And so we thought it would be helpful to you to discuss the litigation this morning and to give you some practical advice on what to do in response. And really, to understand the litigation, I think it's helpful to start from the beginning with 403B plans. 403B plans can be offered by public education organizations, 501c3 entities, employers of ministers, and self-employed ministers. 403B plans date back 60 years, and I think this is an important thing to note as we look at the 403B litigation, that 403B plans predate ERISA. They predate 401k plans. Section 401k was added to the Internal Revenue Code in 1978 and wasn't really used as a retirement vehicle for employees until the 1980s. So 401k plans are a much more recent development than 403B plans. And historically, 403B plans have operated really on an individual by individual basis. They historically were not employee retirement benefit plans in the sense that we view 401k plans or retirement plans today. Historically, they were groups of annuity contracts, and as employees, as faculty would change positions from university to university, they would bring their plan with them. They would bring their vendors, they would bring their investments with them as they changed jobs. And employers were really hands-off on 403B plans through most of the 60-year history of 403B plans. It was really an arrangement that the employees had. Employers did not exercise much administrative function or roles that you would view as a sponsor of the plan. It was really the employee's arrangement. And things started to change about 10 years ago when the Internal Revenue Service issued 403B regulations that became effective January 1, 2009. These regulations were designed to make 403B plans similar to 401k plans and 457B arrangements, to make these plans kind of fall into line with the other somewhat similar elective deferral employee retirement plan arrangements that exist in the marketplace, and also to clarify what you had to do to have a compliant 403B plan. And so these regulations did just that. For the first time, for the 403B plans, we're required to have a written plan document. There are deadlines for depositing salary reduction contributions. They have to be contributed to the plan at least 15 days following the month in which the employee otherwise would have received the compensation. The concept of a control group, where there are several employers that are under common control, have shared board or trustee members, are treated as a single employer for the non-discrimination rules that now, as of 2009, apply to 403B plans. Non-discrimination rules, coverage and amount testing for employer contributions, non-elective contributions, and universal availability requirements for elected deferrals, that if you allow one employee to make an elected deferral into the plan, all employees of the university have to be eligible to make 403B elected deferrals. Limits on the amounts of those annual elected deferrals under Section 402G became applicable to 403B plans. The Code Section 415 annual additions limit, a cap on the total amount of contributions that can be made to the plan on behalf of an employee for a year, apply. The Code Section 401A9, age 70 and a half, required minimum distribution requirements apply. The ability to make a rollover distribution so a participant takes a distribution from their 403B plan, they can roll it within 60 days, roll it into another 403B plan or an IRA or a qualified plan. So as you can see, it was a real, and probably as you have experienced, this was a real sea change for 403B plans about 10 years ago, where they became much more like 401k plans. So that leads us to the second question. Okay, so I have a 403B plan that has to comply with all of these rules that apply to 401k plans. Is the plan also subject to the Employee Retirement Income Security Act, or ERISA? And the answer is yes, possibly. If the sponsor of the 403B plan is other than a government, an Indian tribal government, or a church, in other words, if the sponsor is a private employer, such as a private university, and the plan does not meet a Department of Labor safe harbor that excludes a 403B plan from being subject to ERISA, then your 403B plan, in addition to being subject to the IRS regulations, is also subject to ERISA. The Department of Labor has a long-standing safe harbor in the regulations that exclude 403B plans from being subject to ERISA. The first requirement is that the participation in the plan is completely voluntary. on behalf of the employee. The second requirement is that the annuity contract or custodial account rights are enforceable solely by the employee or beneficiary. In other words, the employer is not a party to the agreement. It's an arrangement between the employee and the annuity provider, and not the employer and the annuity provider. And then the third requirement is that the employer has very limited involvement with the plan. And I think because this is an important point as to whether your plan is subject to ERISA, I'll kind of run through those, the involvement that is permitted by an employer. You are not subject to ERISA even if you permit annuity contractors to publicize the availability of their products to employees. If you request from the annuity provider information regarding the annuity contracts or funds and then summarize or compile that information and share it with employees, that is permissible. The employer can hold in the employee's name one or more group annuity contracts covering the employees, and then an employer can limit the fund options or funding media available to employees to a reasonable amount. So the employer can control the investment or annuity options that are available to employees. So those are activities that an employer can engage in without losing the protection of the Department of Labor's safe harbor. And then finally, the employer cannot receive any direct or indirect compensation as a result of or for providing the administrative services that we just discussed to the plan. So if you meet these requirements, even if the university is a private university, the 403B arrangement or plan that the university has is not subject to ERISA. So again, the regulations required employers to take a fresh look at their 403B plans and to allocate administrative responsibilities between the investment providers and the employer. The Department of Labor has stated that merely complying with the IRS regulations does not necessarily cause the plan to be subject to ERISA. But you have to be careful, again, to limit the amount of discretion that the employer has in administering the plan, and specifically if the employer is controlling planning the plan transfers or deciding which employees, or if the employee qualifies for a hardship withdrawal or processes distributions or is administering qualified domestic relations orders when a participant divorces and there's an alternate payee, a former spouse that wants a share of the retirement plan assets, or administering plan loans. The employer engages in these types of more intensive administrative practices regarding the plan. You run a risk of losing the protection of the Department of Labor safe harbor. So why do we care if the plan is subject to ERISA? Well, there are a lot of requirements under ERISA, and probably the most important, in addition to the reporting and disclosure requirements of ERISA, are ERISA's fiduciary duty requirements, and these requirements are the subject of the University 403B litigation that we will be discussing. ERISA requires a fiduciary to discharge his or her duties under, and really the two most important concepts here are having complete loyalty to the participants and then to act in a prudent manner. And so as you can see here from the list, the first requirement is that the fiduciary must act solely in the interest of participants and beneficiaries. So when a fiduciary is making decisions about the administration of the plan, the selection of investments, the monitoring of investments, the decisions the fiduciary makes in that capacity are made with a sole focus on the interest of participants and beneficiaries and not the employer. The fiduciary has to discharge its duties for the exclusive purpose of providing benefits to participants and defraying reasonable expenses of administering the plan. Third, this is a very important concept for the University 403B litigation. The fiduciary must discharge his or her duties with the care, skill, prudence, and diligence under the circumstances then prevailing that a prudent man acting in a like capacity and familiarity with such matters would use in the conduct of an enterprise of like character and with like aims. Okay, so what does this mean? This means that a fiduciary must act prudently and is held to the standard of an expert in the field in which the decision is being made. So it's not a reasonable person standard. The Erisa fiduciary must act in a prudent manner, measured against what a person with expertise in the area, how that person would behave and the decisions that that person would make. Fiduciary also has to diversify the investments of the plan and also administer the plan in accordance with its governing documents and, of course, in accordance with the law. So that brings us to the University 403B litigation. There has been a coordinated effort by a few, very small number of plaintiffs' law firms to sue over a dozen universities claiming breaches of Erisa fiduciary duties with respect to the administration of their 403B plans. These lawsuits, most of them, have been filed by the firm of, I hope I pronounce this correctly, Schlichter, Bogart, and Denton. This firm, beginning about 10 years ago, also initiated a wave of similar lawsuits regarding 401k plans. And so following the success of their 401k plan litigation, they have now turned their sights onto universities and university 403B plans. The strategy seems to be to initially sue large employers with plans that have significant assets, get favorable rulings, establish precedent that favors them, and then start going after smaller employers and seeking, getting them to settle with them. So if you are a smaller university or a small private college, you may not be hit with the first wave, but it's possible that down the line these lawyers could come knocking at your door. So it's basically a business model. It's maybe a reason some people give lawyers a bad name. That they are they have these theories and it worked in the 401k plan area, and now they're coming after universities. So here's a list of the universities that have been sued so far. Maria assures me that this is a comprehensive list. This list is constantly growing, so it's possible that as of this morning, this list is out of date. But there are some commonalities among the universities here. Their 403B plans all have significant plan assets, and significant, we're talking billions of dollars, so significant plan assets. They also have significantly more investment options offered under their 403B plans than you would see under a typical 401k plan. For example, Duke University has approximately 400 investment options available under their 403B plan. And they also have retained multiple record keepers. So they don't have just one. They have several vendors providing administrative and record-keeping services to their plans. So there's some common factors among these defendants in these lawsuits. And really, if you go back to we talked about the origin of 403B plans, this has really happened really because of the unique nature of 403B plans. That these plans were originally more individual by individual arrangements. And as faculty members changed jobs, they brought their investments and they brought their service providers with them to their new job. Universities were not as hands-on with the administration prior to 2009. And so these collections of investments and record keepers and service providers just organically evolved and grew to the point that where we are today with 403B plans. So there are as you would expect, since there's about one law firm filing these lawsuits, their allegations, there are many common allegations across the board in all of these lawsuits. They typically allege that the universities entered into agreements with record keepers requiring the plans to offer the record keepers proprietary funds and without regard to the best interest of plan participants. They claim that it's a breach of fiduciary duty and imprudent to have multiple record keepers and custodians and trustees, and that this results in excessive fees. The plaintiffs claim that the failure to that these universities did not conduct a competitive bidding process, and on a regular basis they don't put these services out to bid to seek lower fees. They claim that the universities kind of are on autopilot, offering high-cost mutual fund shares when they could use their bargaining power to get institutional lower-cost investment options, and that they're not monitoring the investments, and underperforming investment options are remaining in the plan and not being removed. And then all of those claims are really what were claimed in the 401k fee litigation cases. This final one is unique to the 403B litigation in that the universities have breached fiduciary duty because they offer too many investment options, which results in higher fees and also is confusing to participants. And so those are the common allegations that are being lodged against the universities. And the universities are fighting back. And so almost all of the universities, I think, except for University of Southern California, which has gone a different route, trying to compel arbitration, all the universities have filed motions to dismiss for failure to state a claim. And I think at this point, just to make sure that we're all on the same page, so this is where we are in the litigation. To survive a motion to dismiss, the court has to find that, assuming everything the plaintiffs are claiming is true, that the plaintiffs have stated a plausible claim for relief. So at this stage, the courts aren't making any factual determinations. The courts are just saying, well, you know, the university has said, even if everything the plaintiffs claim, even if it's true, we would win because they haven't stated a plausible claim for relief. And so right now the courts are just saying, okay, we're going to assume that everything the plaintiffs have stated is the case, and under those facts, you know, could they assert a claim for relief? So that's where we are in litigation. And so the universities have argued that the plaintiffs have not stated a claim because of that 403B history that we talked about, that there's a reason that we have so many investment options and so many record keepers and vendors because of the history of 403B plans. They claim that the plaintiffs have failed to allege a flawed investment decision-making process in the way that they select their investments. They have, one of the arguments is everybody else is doing it, and which doesn't work with my 13-year-old daughter, but it's one of the claims they're saying is, well, if you remember the Erisa standard is, did they act as a prudent expert? Are the decisions prudent based on what other prudent experts in the field would make? And the universities are saying, well, the fact that there are over a dozen of us that have been sued, we're all making the same decisions, doesn't that show that we're meeting the prudent standard, that we're acting just as all the other experts in the field are behaving? The universities say that, you know, it's not necessarily imprudent to include an investment just because the fees are higher, because there are a lot of other decisions or a lot of other factors that determine whether an investment is prudent beyond fees. And then regarding you're offering too many investment choices, the universities are saying, well, Erisa just requires us to offer a diversification of investments, and the high number of investment options that we provide give participants choice. So those are the claims, or that's how the universities are fighting back. These are some of the arguments they're making to say that even if you assume everything the plaintiffs have claimed is true, they've failed to state a claim, and so the lawsuit should be dismissed. So I thought, now that we kind of did an overview of all the cases, there are two, we have so far have two decisions on the motions to dismiss. One is in Henderson versus Emory University, and the other is Clark versus Duke University. And I believe both of these were issued in the spring, in May. So I thought it would be helpful to take a little bit of a deeper dive and look at the Emory case and kind of give us an idea of where the courts may be going with these motions to dismiss, and potentially how these cases will end up once they get beyond that stage. So Emory University was a perfect target for this firm. It had two plans. The Emory University Retirement Plan has $2.6 billion in assets and over 20,000 participants as of December 31, 2014. And the Emory Healthcare, Inc. Retirement Savings and Match Plan had $1.6 billion in assets and over 21,000 participants as of December 31, 2014. So we're talking about a university that has 403B plans with assets in excess of $3 billion and over 40,000 participants. So it's right in the crosshairs for this law firm. We're going to go through, basically go through the court's decision on the motion to dismiss and address each claim made by the plaintiffs and whether the claim was allowed or dismissed. But as we go through these, I just kind of want to set the stage, and you're going to see some commonalities and some overlap between the claims. And there are really three broad categories of the claims. And the first one is that Emory failed to monitor and measure against industry benchmarks the plan investment performance, the performance of the investment funds, and as well as the fees charged against participant accounts. The second theme is that Emory failed to consolidate their investment options, and they also failed to consolidate the vendors, the record keepers. And then the third is that Emory entered into agreements with their record keepers that locked them in to certain investments, which prevented Emory from exercising its fiduciary duties of analyzing the investments as to whether they are prudent for the plan. So the first claim I will discuss is the plaintiff's claim that Emory's plans have massive assets. We're talking $3 billion. And with a plan that size has tremendous leverage and bargaining power. And the plaintiffs assert that Emory just failed to use its tremendous bargaining power to try to obtain institutional class shares instead of the higher cost retail class shares that were basically identical. The plaintiffs assert that they identified 76 mutual funds where Emory selected the higher cost retail class share, even though it could have obtained a lower cost but identical investment or institutional class share of the same fund. So the plaintiffs saying that Emory just was on autopilot and didn't use their massive bargaining power, and said in their memorandum opposing the motion to dismiss, stated that that Emory's selection of the menu of retail class funds that were identical to the lower class institutional shares raised a strong inference that Emory imprudently wasted participants' money on wholly unnecessary fees, and that Emory should have known that jumbo plans like its plan could obtain lower fees than that are paid by smaller investors. And so the court agreed, and this claim survived the motion to dismiss, and the court determined that the plaintiff stated a claim for relief, and so this motion will go through, or this claim will go through. The second claim addressed by the court is that Emory offered way too many investment options. The plaintiffs claimed that Emory diluted its massive bargaining power by placing 111 of its investment options of the 3 record keepers and the proprietary funds maintained by the record keepers. And by splitting the funds up among 3 record keepers, lost some of their leverage and bargaining power to get lower fees. The plaintiffs argued that, these are way too many investment options for participants, and many of them were duplicative. For example, they claim that there are 31, I keep saying they claim because these are the facts alleged by the plaintiffs, that the plan offers 31 large cap domestic equity funds and 13 international equity funds. And when you compare that to the typical 401k plan that only has 15 investment options total, that these are way too many investment options, and the plaintiffs claim that this leads to a decision paralysis on behalf of participants, that it's just too much for a participant to handle and to comprehend and to make decisions. The court disagreed. The court dismissed this claim, stating that having too many options does not hurt participants, but it gives them an opportunity to choose. It just gives them more opportunities, more choice is better for participants. So this claim, the claim that offering too many investment options is an Erisa fiduciary breach failed. But let's step back a moment and let's just be honest. If you, as a fiduciary, your responsibility is to monitor the investment options offered under the plan and to ensure that the investment options are prudent and that the fees being charged are reasonable. If a plan has 111 investment options, although that is not per se or necessarily a fiduciary breach, it could lead to other fiduciary breaches because it's almost impossible for you to meet your fiduciary obligations with respect to so many funds. And you think about Duke that has 400. So that's just kind of an aside. The court dismissed this claim, but it could lead, if you have this many investment options, it could lead to, you're just asking for trouble, I think. The next claim is that Emory's use of actively managed funds was imprudent. The plaintiffs allege that Emory should have offered an open investment architecture that would have allowed it to analyze, remove, and add investment funds in the best interest of plan participants and as is prudent. Instead, the plaintiffs claim Emory entered into agreements with record keepers that required it to include actively managed funds offered by the record keepers in the plan. So these funds, the plaintiffs argue, were not offered because they were prudent or because they were in the best interest of plan participants, but simply because they were required under the agreements entered into between Emory and the record providers. And so there was no analysis of these funds as to whether they were prudent and should be offered under the plan. So really this claim is about the process, that Emory did not do a proper analysis, was even prevented from doing a proper analysis because of these agreements. And the court agreed, or the court refused to dismiss this claim. This claim is allowed. Agreed that plaintiffs have alleged that the defendant's process for choosing and analyzing certain funds was flawed. So this claim will proceed. The next claim, the plaintiffs claim that the fees under the plan were excessive, and they point specifically to the CREF variable annuity accounts included under the plan. They had 4 fees: an administrative expense charge, a distribution expense charge, a mortality expense risk charge, and an investment advisory charge. The TIA real estate account also had a 5th charge for a liquidity guarantee. The plaintiffs assert that Emory did not calculate how much TIAA was receiving in fees, either through direct payment or through revenue sharing, performed no analysis on whether these fees were reasonable or even required. They alleged that some of the fees were not even appropriate for the participants and for the plans. And the court agreed that the plaintiff stated a claim for relief that the fees, that the improper analysis of the fees and the fees that are charged should actually be fees that benefit the participants and not benefit the fund provider over the participants. The next claim is that Emory just was not monitoring the investment performance of funds offered under the plan. And in particular, the CREF stock account had a long history of underperformance, and the TIA real estate account likewise had a long history of underperformance, and that the CREF stock account had unnecessary fees and performed for years poorly. And despite the many years of underperformance, the fees remained in the plan. And basically the plaintiffs argue that Emory failed to analyze whether the plan's actively managed funds were likely to outperform industry benchmarks. So they claimed that it was a fiduciary breach to not measure these funds against industry benchmarks. And it's a result of this failure to monitor that participants potentially lost millions of dollars because they were invested in these poorly managed funds. And the court agreed and allowed this claim to proceed. In kind of a similar vein, the plaintiffs argue that Emory's revenue sharing method was improper and overcompensated record keepers, that Emory simply was, they claim Emory was asleep at the wheel and did not monitor the revenue sharing, did not do any analysis of the fees being paid through revenue sharing. And the court agreed with the plaintiffs again that Emory could be held accountable for failure to monitor and making sure that the record keepers were charging appropriate fees. The next claim is that the plaintiffs, that the plan had too many record keepers, that Emory should have done an analysis of its record keepers, and that other universities had performed an analysis and had reduced the number of record keepers to one. The plaintiffs claimed that Emory failed to do this similar analysis and also did not put the record-keeping services out to bid. That, again, they're claiming Emory was on autopilot, did no analysis of whether it should have the 3 record keepers, didn't put it out to bid, so the Emory had no idea what reasonable fees were. And according to the plaintiffs, the plans paid $8.1 million per year and $594 per participant, which is, of course, significantly higher than the reasonable market rate of $30 per participant in fees. So the plaintiffs are just, again, it's a common theme saying Emory failed to monitor and failed to analyze the fees and investments in the plan and it cost participants. And the court allowed this claim to proceed as well. And finally, the plaintiffs claimed that Emory improperly locked itself in to TIA CREF products by entering into agreements that, there was an agreement that the TIA annuity option would be included in the plan only if Emory agreed to use TIA as a record keeper and included the CREF stock and money market accounts in the plan. So again, these investments in the record keeper were not chosen, according to the plaintiffs, based on an analysis of what was in the best interest of plan participants, but instead Emory had locked itself in to offering these investments and using TIA as a record keeper. And the plaintiffs argue that Emory violated the most basic of Erisa duties of investigating plan investments and could not even fulfill its duty to monitor because it had locked itself into these agreements. According to the plaintiffs, a prudent fiduciary would have removed the CREF stock account in 2010 because of its underperformance and therefore preventing millions of dollars of losses to plan participants. because these agreements were entered into more than 6 years before the complaint was filed, Erisa has a 6-year statute of limitations on these types of claims. The court dismissed the claim to the extent that it relates or seeks damages relating to actions that occurred more than 6 years before the complaint was filed, but allowed the claim to the extent that the damages occurred within the 6-year window prior to the complaint. So, in essence, the court also allowed this claim to proceed with the caveat that it's limited to the 6 years going back. So that's the Emory case. The court in Clark versus Duke University issued a very short decision on the motion to dismiss, but I thought it would be helpful to compare Emory and Duke cases and really to point out that a lot of these claims have survived the motion to dismiss. So the claim that you're offering too many investment options and that is per se a violation of Erisa, both the Duke and Emory courts dismissed those claims. The locked-in argument that we just discussed, of course, the Emory court allowed that claim. The Duke court dismissed it. You're offering too many investment options. Again, the Emory court determined that was fine, that it was good for participants, that they're educated, smart investors, and they have a lot of choices, that that's a good thing. The Duke court disagreed and allowed the claim that offering too many investment options could be determined to be imprudent and a breach of the Erisa fiduciary duties. Both courts allowed the claims regarding too many record keepers. Both courts allowed the claims that the universities maintain underperforming and higher cost investment options. And then both courts allowed claims regarding the failure to engage in a proper selection process for plan record keepers. So far, I'm not even sure I would say the results are mixed. I think it's a pessimistic view as these claims are moving forward. They're surviving the motion to dismiss. And so that brings us to what do we do from here? How do we respond to this? Again, just remember the themes here. It's like almost like a broken record going over each of these claims because a lot of them are really related to a basic failure or assertion that there was a failure to monitor the plan investments, to monitor the fees, to analyze fees, to measure the investments and fees against industry benchmarks, to use the plan's bargaining power, and to not enter into agreements that would prevent a fiduciary from meeting its fiduciary obligation under ERISA. So what are some basic practical things that we can do? First, if you have an investment policy statement and you haven't seen it for a while, take it off the shelf and dust it off and take a look at your investment policy statement. If you do not have an investment policy statement, then you should adopt one. You should draft one and adopt an investment policy statement. The second thing is you should have an investment committee, and that committee should hold regular meetings. I think quarterly is a good frequency. And review the investment performance of the investments under the plan, review your fees, compare the investments and fees to industry benchmarks, review your investment options against your policy statement. And these meetings should be recorded in minutes. Under ERISA, you don't necessarily have an ERISA fiduciary breach because you made the wrong decision. You have an ERISA fiduciary breach if you didn't engage in your due diligence and the process of making your decision that shows that you were acting in the best interest of plan participants and making decisions that a prudent expert would have made. And so it's really important if you get sued, hopefully that won't happen, but that you have these minutes from your regular investment committee meetings that show the reasonable basis for the decisions to retain certain investment options and to have certain fees paid by the plan. Third, it's good to ensure that your plan fiduciaries and your members of these committees understand their responsibilities under ERISA to provide some ERISA fiduciary training to your fiduciaries. Your policy statement, your investment policy statement should require the plan to have a diverse selection of investment options. But you should analyze whether, do we have too many investment choices under the plan? Can we meet our fiduciary obligation to monitor these investments if we have 50 investment options or 111 investment options as Emory had or 400 as Duke had? Does that make sense? You should make sure that the plan is always paying the lowest cost mutual fund shares or have the lowest cost mutual fund shares available. It's possible that the plan assets have grown, and as that plan assets grow, the plan gets more bargaining power and can move from higher cost shares to lower cost shares. And so that should be part of the investment committee's role, is to make sure that you are always offering the lowest cost mutual fund shares. If the plan has more than one record keeper, you should consider consolidating the record keepers into one and document that process. And finally, to plug for our colleagues in the industry, I think it's really helpful to hire an independent investment advisor to lead the committee through these decisions because, again, you aren't held to a reasonable person standard. Under ERISA, you're held to a prudent expert standard, and so it makes sense to hire an expert to advise the committee. And so with that, I guess if we have any questions, we can answer questions.
We have one question here, and it reflects back to that table, Brydon. Could you flip back to the table?
Sure.
What is the difference between the first and the third too many investment options and the offered too many investment options?
Sure. Marie's going to answer for me.
Hello, everyone. This is Marie. My apologies. The very first one is supposed to be investing in TIA mutual funds created a prohibited transaction because TIA is a plan record keeper. That should have been the first one on that. The actual offered too many investment options looks like it's number 3 on you all's list. That is, excuse me one second. The Henderson versus Emory Court dismissed that, but the Clark v. Duke University allowed that to proceed. That is the correct. I just want to make that comment here.
I guess it looks like a typo on that PowerPoint. I apologize. But one of the differences perhaps between Emory and Duke is that Duke had over 400 investment options and Emory had 111, which could be a distinction between those two cases.
Okay, we have another question. Are public universities considered government entities, and if so, can they be exempt from ERISA fiduciary requirements?
I'm glad you asked that question because I had it in my notes to address this. So public universities are not subject to ERISA. They are governmental entities, and they are exempt from ERISA. However, ERISA's fiduciary duties, when ERISA was enacted, were borrowed from state trust law. So public universities are not out of the woods because similar claims could be made, but they wouldn't be made under ERISA. They would be made under state law. So the concepts are very similar. The duties of loyalty and the duties of prudence in the decision-making under the plan are very similar, and those state trust law requirements predate ERISA. So public universities are not off the hook.
Okay, and final question here. Any recommendations for non-ERISA plans?
I think the recommendations are exactly the same. I think the same analysis should be performed for non-ERISA plans.
You mind if I speak?
Yeah, good. Marc looks like he wanted to say something.
Hi, this is Marc Purintun, and I'm one of Brydon's partners and work regularly with governmental and some church plans that have 403B or 403B plans. And so they're not subject to ERISA, and therefore some of these prohibited transactions, which is an ERISA term of art, wouldn't apply. But the general rules of loyalty, that the trustees and fiduciaries responsible for the 403B plan must act in the best interest of the beneficiaries and participants of the plan still exists under state law and still could be enforced in state court. And the duty of prudence, which was developed over many, many centuries under state trust law that was incorporated into Erisa, is still the same duty with the same high standard of a prudent person familiar with the same type of investment options and same type of business would also apply. And so I think, though you may not have the same prohibited transaction rules, you certainly operate within the same scope of fiduciary potential liability. So a best practice is to try to show that the fiduciaries for the governmental plan or the church 403B plan are trying to have the most prudent process to select prudent investments and to document everything that they do. And just that, actually want to add that to what Brydon said. Documentation is key. No matter how prudent the process is, if you spend an hour and a half reviewing all the information about an investment and about its fees and about the past and expected future prudence of that investment, but all you do is document the committee reviewed this and took no action, then you probably don't have a good record. And then when the law firm comes and challenges whether you've acted prudently, it's more difficult to defend.
And that's, if you hire an independent investment advisor, you're likely to have a lot of the documentation and support, and in fact, sometimes they'll even prepare your minutes for those decisions. So that's another advantage of doing that. But yes, documentation is key.
Do we have time for one more question?
Sure.
Can you give key points on how to maintain non-ERISA status?
Well, we can go back to the Department of Labor safe harbor. So, again, even if you are a private employer, if your 403B plan meets these requirements, that you don't require participants to participate, the agreements are between the employees and the annuity provider. There's limited employer involvement, which is basically the employer can collect information, can share information about the 403B plans. The employer can take salary elected deferrals and remit them to the investment provider, and the employer can select or provide a lineup of investments. If you're limited to those activities, then you would meet the Department of Labor safe harbor and not be subject to ERISA. And so that's really what you would need to do.
So I would just to add in there, the key issue is really going to be this is only a 403B plan that only allows elective contributions.
Right, no employer contribution.
By the employees. The minute there's a match or that there's some other employer non-elective contribution added to this plan, the plan is an ERISA plan if it's not a governmental plan or a church plan. So the key here is just the minimal amount of interaction between the employer and the plan.
Right.
All right. Brydon, thank you very much. That was an informative presentation. And folks, if you have additional questions in this afternoon and the days to come, I would encourage you to reach out to Brydon, to Marc, or Marie, or myself. We'd be happy to engage with you and get you answers to those questions. You will see our contact information on the screen now, and I think it's also included in the presentation that was provided to you, the materials. We hope that you and your colleagues will join us again on October 4th for the seminar here in Richmond. And on behalf of our partners in this education practice, Ernst & Young, Marsh, Mercer, and us here at Williams Mullen. We want to thank you for joining us and hope you have a good afternoon.